Very warm welcome, ladies and gentlemen. Thank you for taking the time to be with us today. And I would like to welcome you to another webinar in our M&A Masters series. This is the 9th webinar in our 2025 series. My name is Samir Shah, and I'm a partner in Khaitan's Corporate M&A Group. And we look forward to today's webinar with all of you, whether you're listening in live or you're accessing the recording, which will be available on YouTube. A quick introduction on the program. The program itself was designed to provide all of our listeners and our audience information on contemporary M&A issues so that they gather a peek into a sophisticated set of instruction. And this is obviously useful for experienced corporate executives, in-house legal teams, investment banks, and any other intermediaries or market participants who are interested in M&A in India today. Our subject today will be M&A Cross Border due diligence. And on the slide in front of you, you have the agenda for today's webinar. If you do have any questions, please submit them using the facility provided in the webinar portal. We've, of course, received quite a few questions as a part of our registration and have woven them into the panel discussion. Of course, whatever questions we cannot cover today, we will respond offline by email after the webinar. Please note that summary notes of today's panel discussion and the recording of this webinar will also be sent to you after the webinar as a matter of course. To quickly talk about the topic and why we've chosen this, essentially as a firm, we've increasingly observed that cross-border transactions are becoming complex and due diligence has moved beyond a simple tick-the-box compliance exercise to a very critical component of deal strategy and deal success. Effective diligence today requires not only identifying legal, financial, tax, or regulatory risks, but also assessing how those risks impact valuation, deal structure, or for that matter, post-merger integration. In the discussion today, I will invite our panelists to explore from their experience how deal teams can conduct due diligence that is more commercially focused, cross-functional, but eventually outcome-driven. We will be discussing key focus areas on cross-border transactions, including how to manage information flow, coordination across jurisdictions, and translating diligence outcomes into deal value and integration readiness. With that, let me introduce our panel today. Everyone who has registered for this webinar should have received by email a summary of the speakers and their credentials. Suffice to say that they are all experts in their subject matter and immensely qualified to express their views and opinions on the subject matter today. To begin with, we have Mr. Siddhant Gupta, who is a partner for strategy and transactions at EY. Along with him are my partners Sharad Abhyankar and Karthike Prakash, both of whom are also part of our corporate M&A practice. And between the three of them, they bring immense experience to this panel. So with that, let's start with our discussion. And to kick things off, perhaps I will invite all three, Sharad, Siddhant, and Karthike, to express their views one by one on what, in their experience, are the key differences when it comes to conducting, let's say, cross-border due diligence, or for that matter, conducting domestic due diligence in a purely domestic scenario. Why don't we start with Siddhant? And maybe I can request Sharad after that and then Karthike. Siddhant, you're on mute.
Apologies for that. Thanks, Amin. Thanks for the introduction, and it's a pleasure to be a part of this webinar series with Khaitan and company. I've been involved in several cross-border transactions over the last 12 years, focused on technology, media, and telecommunications as a segment, and doing cross-border transactions both outbound and inbound is par for course. Key differences with respect to inbound transactions, outbound transactions versus a domestic transaction. While the obvious ones would be it's a different legal jurisdiction and a different regulatory framework, I can bucket the key differences to be in 4 or 5 key areas. One, the culture of the company and the target which you're kind of looking at would be different compared to the people who are evaluating. There would be nuances with respect to difference in accounting policies and accounting standards. Some companies follow US GAAP, Europe will follow their own local GAAP versus India follows an Indian GAAP and Ind AS, which would have differences. Uh, Very obviously, there would be differences and complexities compared to a domestic transaction with respect to currency fluctuations. There would be, foreign exchange gains and losses, which need to be treated accordingly. And to a very large extent, two buckets which comes to my mind would be employment laws. Employment laws in different jurisdictions are to be treated very differently. They have different implications in terms of how the deal needs to be structured, deal value, as well as treatment of several items, be it pensions, be it benefit plans, be it any other retirement policies. As well as the another bucket is taxation. Given local jurisdiction, tax laws are fairly different, and at times we'll have to kind of go and involve our local tax colleagues in different offices across the globe to get to the right aspects. But taxation is another area which needs to be deep dived. Given in a cross-border transaction, there would be areas of residents transacting and non-residents transacting from different jurisdictions, which just adds to the complexity of the transaction. I'll just pause here and hand over to other colleagues of mine.
Yeah, thanks, Siddhant. That was quite a comprehensive list of things. So, the entire theory of diligence starts with buyer beware. There is there are very few laws, at least in India, which cast a duty to have a diligence before you get into a transaction. But obviously, in all significant commercial transactions, diligence becomes quite imminent and essential. So one of the things that becomes very critical is that while you have different teams, different firms, different workflows for legal, financial, technical, commercial, cultural, uh, when all these teams are really doing their diligence activities, there should be a common briefing to all, because in every transaction there is some one or more focus areas for the proposed transaction. What is the prime really motivator for undertaking or considering a transaction? So whether it is property, whether it's business, whether it's resources, whether it's IP, a particular patent, there can be a different reason why an acquirer is really looking at a potential transaction. So giving a common briefing will give them that one single direction, so that they remain focused. So in terms of key differences, I think one of the critical legal difference arises from the fact that each country has a very different legal system. So not that every country has an Anglo-Saxon or a common law. There are also some mixed jurisdictions. So understanding the legal framework, how the legal system works, can be one of the big differences, because all of us come from a typical traditional our own domestic backgrounds and understanding as to how the legal systems work. So I think one of the biggest issues that we have to deal with is to look for a local expert who will be really be able to guide you through the nuances of the local laws, enforcement, what are the mechanisms, what are the regulations. So the other thing that has, of course, in many sectors, very critical. On one hand, we talk about, many countries have full capital account convertibility, and at the same time, I think there are almost all countries, foreign investments and transfers of capital instruments is clearly subjected to scrutiny, regulation, and at times even prior approvals from the government. So when we talk about potential transactions, I think the what are the regulatory roadblocks or process elements that become very crucial. There are certain sectors which are obviously more critical. Uh, Say, for example, aerospace, technology, atomic energy, defense. these are very core sectors where each jurisdiction may have their own sensitivity and therefore very peculiar regulations uh, carved out for that sector. So awareness of those sectoral guidelines, sectoral requirements, and even primarily, even before you get into a term sheet, I think whether such a foreign investment is permissible, and if so, to what extent, subject to what conditions, I think that awareness becomes very crucial. Siddharth, you also talked about cultural fit and alignment. Absolutely bang on, because every target's corporate culture and management style is very different. So it's quite possible that from initial meeting from the target stock management and general reputation across the markets, it's possible that you notice some dramatic cultural changes or differences and management styles. So even at the stage of term sheet or even pre-term sheet, it's quite possible. How do we address the management retention, integration plans, governance structures, cross-cultural communications? Now, these become very, very crucial for a potential successful transaction. So I'll stop there. Karthik, please feel free to add your issues.
Thank you, Sharad, and Samir. Very valid point. And I think whilst Siddhant and Sharad has kind of covered, I think if I need to summarize it, I would say, let's say a domestic deal and a domestic deal-focused diligence. If one were to consider it as a 400-meter race, cross-border is really a relay. Okay, and with customs coming in between to create the hoops. And I think the entire trick is what actually Sharad mentioned, and I'll use the word, the designing the layout for the diligence, or in another way, choreography of the diligence story. So it's a multiple laws periphery, but the story remains same. That's one story. Ultimately, the deal has to go through. So I think, of course, I mean the cultural fit, to have the one theme in every lawyer or every jurisdiction counsel mind to go through the deal is of course the story. But I mean, just to add 2-3 more bullets on this, another big point which come across these deals is the information asymmetry. So different jurisdiction, different nature and custom of flowing the information. Some developed jurisdiction will say, hey, look, I can't share the salary data upfront. That's the second layer. Somebody would say, okay, fine, everything is here in the data room, you figure it out. So information asymmetry is another challenge, especially when you are dealing into a multi-jurisdictional cross-border deal. Of course, regulatory part and restrictions, the way Sharad indicated, I have an interesting story. I'll just come to that. But before that, of course, that's a part. And I think the second one is, which is also very critical, what's really the impact, which you started the webinar with, that ultimately this exercise has to have a meaning. So what's really the papering impact of this exercise is? I mean, an India-focused deal, a lot more will go into indemnity. A US-focused deal will have a different approach. A European-focused deal will be a very different approach altogether. So when you are dealing into a cross-border or a multi-jurisdictional target, or as an acquirer, you are dealing into these jurisdictions, what's the underlying theme where all of this intel get folded in? Otherwise, I mean, if there's no a real impact of the diligence finding, then it's more like a Wikipedia or more like a trivia for everyone to read. So that really becomes a interesting point. On this, I mean, just one example. I know we are belaboring on the point one itself, and there's a lot more to cover, but very quickly, very interesting. We were dealing with a retail business in a Southeast Asian country. It's more like a retail shop chain in that country, with a structure which involved, of course, Singapore and one of the countries in Europe as well. And we were running that deal. I mean, not really so much of an India connection, but as a lead counsel, project counsel. And we, of course, roped in counsels from all 3 jurisdictions. And the very interesting thing, during almost towards the end of the diligence, we got to know, and perhaps, I mean, my learning was that should have been thrown to us in the very beginning, that in that Southeast Asian country, the foreign investment is linked to each store that company can operate. So very interesting. I mean, in India, we have sectoral cap. We are aware of pricing, but we always see it as an entity level a marker. we never see it at store level. So if you have 100 store, each store can perhaps attract 5 million. So you can raise up to X amount of foreign investment. And similarly, that becomes the check for the past investments, that if you have raised those money, have you used it to open this store or not? That came in quite late. Of course, we had the wherewithal to get the check done and all, but that became one of the perhaps a weak point, which took almost a week for everybody to deliberate, bring everyone around that point. So, I'll take a pause on this one. Samir, over to you.
I think that's great. I think that's a fantastic starting point. And maybe what I will do is my next question is to Sharad. And Sharad, you spoke about buyer beware, and that's really the genesis of this entire exercise. When in the entire process, because it's a process, when in the entire process should legal due diligence be commenced? What's the right time in your experience?
So I would say ASAP, because if you have identified any potential target even before you sign a term sheet, I think there is a huge public domain databases which are available. I think that scrutiny is very critical for you to at least ascertain whether you want to go ahead even with the term sheet. So let me explain a few directional searches that we can definitely do. There can be searches for regulatory actions. There can be a lot of early warning signals kind of searches, that are there reputational issues, are there legal issues, are there publicly known litigations. Most of the directors or KMPs who are officiating on the target. Where else are they directors? Where else are they officiating? In what capacity? Are there cross investments by the target entity? Uh, there could be data relating to credit scores. There could be data publicly available about foreign exchange violations. There could be data about willful defaulters. So I think all of that information must be gathered well upfront. There may be suits relating to, say, patent infringement, which is for the core product that the company has. There could be some murmurs of financial distress in some remote corner of that company's overall business. So all these can definitely facilitate not just a decision whether a party is the right target, but also to customize your expectations and the depth of the diligence, which particular area you will focus deeper, so that you get the right answers and then take it forward. But I would say as soon as possible. I mean, whenever you even think that there is a potential target, do your homework before you even start that initial discussion.
Perfect. And Karthikeya, you gave a very interesting example of how it could be entity specific or location specific. Let's say if you were to advise on a cross-border transaction involving an Indian target or an Indian investor, whichever way you look at it, what are the common regulatory approvals which you feel impact cross-border M&A and therefore need to be a focal point early on in the due diligence process for an acquirer?
No, very valid question, Samir. I think I'll pick up the inbound India deal as an example. I mean, we are India practicing lawyer. I'll first focus on that bit. And you are right. I think this question get asked every time you do a cross-border deal in some shape and form. Perhaps not so vocally, but underlying, I mean, this is the theme. So I'll put it like this. I think a cross-border deal in India, and again, I'm using a summarized sentence, but I feel deals don't fall because of lack of interest. Okay, they mostly fall because of lack of clearance, and clearance. I mean, whether it came on time, whether they were aware, whether it thrown at a last stage, all those will lead to. So that the clearance or the thought around the approval become the key point to determine the deal success. Now, when it comes into a counsel's domain or as an advisor to navigate this, I would simplify. I mean, thankfully, with now almost 3 decades of work, the foreign investment and the regulations around it has liberalized significantly in India. The ease of business has gone up. I mean, a lot of good capital has come in. Companies are doing really well. With all that theme and how it has, I mean, come up on the surface, I think if one were to really look, there are basic three P's rule. And when I use the word three P's, I will call the first P as permissions, the second as prudence, and third as the path. And when I get into the permissions, perhaps I'll break it further into the kind of the key regulators we get to interact on most of these deals, or where the foreign investments are inflowing in abundance. And the first, of course, will be the foreign exchange regulation and FEMA and the underlying regulators. And there, I think the checks are fairly straightforward. If you know the business, you know the target, you know the buyer or investor, then the idea about route checking, uh, the instrument or the way the transaction is structured, or the pricing or the reporting for the past investments, all that come within the same periphery. And you have to look at it holistically, that whether it has been in line with what the law required it to be, and whether it would be in line for the upcoming investment. So FEMA as one bucket. Then, of course, competition regulator, antitrust regulator become another one. And again, the test will be very fairly simple. I mean, you of course have to start from the exemption thresholds, deal value, DVT, thereafter gun jumping. I mean, if it is more systemic and you are getting into the same domain, and then how you navigate around it. I mean, of course, right now in the market, I mean, unfortunately, if there is any investigations going on, how would you tackle those? Those becomes additional key questions and a tricky one to navigate on these deals. But I mean, those are more situation specific, so I'm keeping it aside. Third, of course, will be your, I mean, had it been, I mean, if we are talking about a listed or a or SEBI-regulated entities, then that becomes another complexity on open offers. I mean, insider trading, how you conduct your diligence, those become the relevant pointer, and accordingly the permissions which it will throw for you to consider in the deal. And the last bucket perhaps into it will be sectoral regulator. Of course, RBI one becoming for financial services, IRDA for insurance and insurance tech companies. Similarly for telecom, there are certain things in a transaction which would warrant your approvals, so you get to see those. So I mean, if holistically I look last few years of deals, I mean, these primarily will be the regulators where there are touch points and you need to evaluate. So that's really the part of the permissions I've come across. When I say prudence, my thought is, so one is, I mean, whenever you are doing a deal, you are looking, okay, whether these apply and whether you are looking for approval or not. The second is you also do some sanity checks around it. You do the sanctions, you do the ultimate beneficial ownership check, you do the PN3 origin checks, whether your buyer, seller, or any interest on that is triggering any of these requirements, any other security overlays in sensitive sectors. Is there anything else which is required? Those does not come up upfront. You have to actually take the prudent path to go and dig it out. So that's the second bit. And the third is the path, which is more around sequencing the entire deal, I would say, from signing to closing, the typical order. I mean, okay, whether you are signing the term sheet documentation, then sectoral or CCI or the relevant approval, then getting into the closing. Closing will entail certain filings, then the annual filing, post-close reports, and all those sort of things. So, I mean, that's really broadly, I mean, the three Ps: permission, prudence, and path. And I'll take 30 more seconds. Samir, I think one more interesting story, again, very thought-provoking. We were doing a deal with a Oceanian company. It's a greenfield JV in a very emerging sector. And of course, the target was sitting in the Oceania. And the diligence was done by a local law firm. And we were sitting negotiating the final JV doc. And then the question came up that, hey, I mean, one of the names sound very familiar and a Southeast Asian name. Actually, I would say a Indian subcontinent name. And I mean, just a general reference, we asked that whether this guy is connected to us. And then we got to know that while the gentleman was always, build the business and empire in Oceania, he has a dual passport from one of the neighboring countries in India. And that discovery on that almost finalized stage of documentation took almost a couple of months to navigate through it, structure through it. Of course, a PN3 approval would have taken much more, but to address that bet. So that was quite thought-provoking for us to see the real impact. And there was no way the Indian lawyers could have gotten to know it upfront till the cap table got fixed in the JV document. Yeah. Over to you,
So
sir.
that's a great story, and I must say Karthik is quite the storyteller, ladies and gentlemen. I do encourage you to interact with him offline. He tends to pull these out from somewhere to illustrate his point really beautifully. With that, over to you, Siddhant. Just a question now. Sharad spoke about when to start. Karthik gave some examples from his experience. I'd love to hear from your experience as to what, let's say, if you had to pick the top three or top five red flags that you see most commonly occurring from such diligences. What is it that you see?
Sure. So, from a diligence perspective, most of the issues would depend in terms of what kind of asset and target you are really evaluating. So, apart from the sectoral specific issues, which would be different, the most common issues from a cross-border diligence would basically arise because of a few specific buckets. One, most of these assets, specifically multinationals, would be into different accounting regimes. They are into different jurisdictions. So, like in India, you would understand that most of the corporates require an auditing, which is a mandatory requirement both from a tax and a company law perspective. But several jurisdictions across the globe do not have this requirement. So, when you're doing an outbound transactions, you know, the investors may assume that the financials are audited, which may not be the case. And sometimes the audit requirement is not even there for some of the mid-sized companies, which may go up to $100-200 million requirements, where there is no statutory requirement, but they may have done the audits based on a special purpose. So it becomes important to understand how those audits have been done. Are the financial numbers really kosher? And what accounting gap have they used? Because what you see domestically versus to an outbound transaction, the numbers may not kind of reflect the same level of accounting and a financial stack, and hence may not be comparable. A very simple example, like in IFRS and Ind AS, which is the global accounting standard and the Indian accounting standard, lease rentals, which are premise and facility rentals, would be accounted differently compared to what you would see in a local GAAP in Netherlands or Singapore, or even for that matter a US GAAP. So the comparability of numbers becomes difficult, and hence that should be the first red flag. Second, it depends on the size of the target which you are evaluating outside. Several of the jurisdictions allow companies to kind of maintain non-accrual based financials. So, several of them would be doing accounting based on cash basis or the hybrid of cash and accrual, which again renders, from a financial and tax perspective, some of these financial numbers non-readable. So they may show a lot of fluctuation year on year. And hence, in the deal year, if you're kind of picking up a lot of variation in revenue, increased profitability, that may not be the most sustainable performance. And hence, it has to be kind of looked at from that lens. So, these two important aspects are there. Apart from that, from a cross-border diligence, it always becomes important how, as I touched upon earlier, how currency losses and currency treatments are being treated. If you're looking at an inbound transaction, several investors would be apprehensive that with depreciating rupee versus British pound or US dollar, how that is impacting financial performance, and to what extent the increased profitability of the company, or what component of the profits are really arising out of just simply a forex depreciation versus the real performance of the business. So the right treatment to forex gains and losses and currency movements becomes very, very paramount, given it will have a direct impact in terms of how several investors, both in an outbound versus an inbound deal, would be valuing the target. Apart from that, whenever you are doing a multinational, evaluating a multinational target, several of the entities may have an opaque corporate structure. And we, of course, as financial and tax diligence advisors, along with legal counsel friends, do evaluate in terms of how the money flow has happened. Are the entities being structured in a manner where the transaction would go through successfully? We need to be apprehensive of where there could be potential tax leakages. if where the cash buildup is happening across the globe, specifically in a multinational scenario, which country is accumulating cash versus which country is the more cash spender, and accordingly, the deal needs to be structured in a particular manner so that the deal becomes more success rather than kind of doing diligence and not really reaching to a conclusion. So I think I would probably keep it here that these are some of the common issues which we would typically see in a cross border and a multinational sort of scenario.
Sorry, I was on mute. No, that's interesting, Siddhant. And while I wasn't originally planning to bring in Sharad and Kartikeya on this, but I'm just wondering if I throw the same question to them, and Sharad, Kartikeya, take a short pause each. What are your sort of most common red flags you see in your cross-border due diligence?
So for inbound, I think the inbound and outbound, particularly when the ownership structures are family driven, I think those structures, possibility of related party transactions and leakages. Incidentally, hidden unemployment is not only in India, it is quite uh, all over the place. And therefore, whether your profitability statements are really justifiable, uh, that's a that's a serious exercise sometimes. Any pending investigations for fraud or any dubious transaction, any regulatory actions that we have seen as a very common ground for red flagging. IP ownership at times becomes a big challenge because the IP ownership may be concentrated in either individuals or group of individuals or a different entity, and then it gets licensed all across the group. So whether they are appropriately documented, whether they are appropriately remunerated for those kind of licensing, that is again a fairly common problem. Uh, the whether in different jurisdictions there is adequate research on the right to operate a patent or right to operate the IP is something which we need to at times get into that exercise during the diligence to make sure that it's all good and fine. I think the last item on my list on red flags would be some of the HR practices. We have already seen, at least for the inbound, the different interpretation that were prevalent on what is the basic salary, and we all know what happened after the Supreme Court judgment as to restructuring of those pay packages and the mandatory employee related benefits, how that changed the entire economics at times of the whole transaction. Uh, the last one, when on the diligence, very interesting things can happen. We were doing a diligence, and all the environmental licenses were absolutely fine, so there was no problem. And we had a call with the technical team, and technical team said that how on earth can you approve this transaction? And we were quite nonplussed. We said, what happened? They said, no, there may be a environmental approval for this particular emission mast, but clearly it is only 60 feet tall, and I don't think it is technically advisable to have anything less than 100 feet tall masts. So when you have these contrast between what the technical team is going to conclude and what the legal team is going to conclude, that can be a throw a different challenge to you altogether. I mean, just to continue Karthik's storytelling, we had completed almost all sorts of diligences and there was no issue. And the technical team of the acquirer came in. They were Europeans. They came into India. They looked at the entire facility, and then we had suddenly a cozy meeting called to say that, you know what, we have absolutely nothing against the target. We have absolutely nothing to comment on the outcome of the diligence, but we have an issue. And the issue is your entire manufacturing facility, all of them, and then they were three of them. The roofing of that factory in those days, I'm talking about quite some years back, this was entirely using asbestos, and they said, no way we will allow our factories to be roofed using asbestos. That's a clear environmental no for us. And if we were to even think about a replacement cost, that would make the entire transaction unviable. And that's where the transaction actually was called off. So there can be very different red flags coming even from environmental issues, and that can happen even at the last moment because of a technical observation. Over to you, Karthik.
Oh, I think you and Siddharth have covered most of it. Samir, you are putting me in a spot every time after these two gentlemen. but coming back, I think
You have good stories to
Find
tell.
that story. You have to find that story.
no, I have to
I,
really
I can add a story for this one, maybe Karthikeya, if you allow. So we were going through a transaction which is an outbound transaction with an Indian investor investing into a French asset. It's an M&A between two strategic players, and both of them are into technology services and software. Very different regimes, but very different, very similar sort of businesses. One is an Indian business which is catering to Indian and US customers, while the European business, the French business, was catering to Europe and again US customers. So there was several pieces of familiarity, and though different regimes. And of course, we came across towards the end that the while the costs, and there was no financial issue from a financial diligence perspective, we identified that the target in France has been using a lot of contractors, and because they were similar businesses, the data flow was a bit more restricted given confidentiality norms and commercial sensitivity, that both are similar businesses and you may have access to each other's customers. So while the information came in a limited manner, use of contractors become a big issue. The way the contractors contracts subcontractor agreements were drafted, they were probably not up to mark, wherein there could be a large chunk of liability which may entail on the company just because of employment rights. And employment rights in France, as when we kind of reached out to a foreign legal counsel, we understood that they are fairly strict and robust, and bypassing them could be a difficult task. And it took us at least a few months to align in terms of what would be the revised structure of employment, how many people would be regularized, what's the corresponding cost and valuation impact, and then kind of we proceeded with the deal. But yeah, some of these nuances would largely be jurisdiction specific and sector specific. As Sharad mentioned in his example with respect to a manufacturing unit where environmental issues became a last moment deal breaker. So over to you, Sami.
So I think, I mean, if we have one more minute, I think a new trend on this piece, yeah. And I know, I mean, I'll still contribute on this point. I think what we are seeing, I mean, of course, I mean, all the key regular red flags we see, I think, has been covered. And of course, a few new things which I'm seeing in last couple of years, and also it's a quality of money which is flowing into India. Perhaps it's doing of that as well. One, of course, is, I mean, little more on a regular side, data localization gaps. That has become for certain kind of sectors, that has become a very prickly point. ESG, which of course Sharad picked the example, but overall ESG compliance have become slightly more mainstream. But jumping from these two, not really an Indian law, but the kind of investor we see regularly now in India, the American law around banking holdings, a lot of those private equity and venture capital funds, which has the BHCA mandate, those also becomes a loop. And you need to, I mean, a handful of people who do that regularly, aware of it, and then thereafter you navigate that. So it's not really a diligence on the target per se, but it becomes one of the critical point to navigate through the deal, and thereafter how it plays out. Similarly, I mean, you have money flowing from pension fund. They have their own restriction in terms of what percentage threshold for what sort of a right on governance they can take into the targets. And that has also become kind of frequent into Indian inbound stories. And again, whether you are the target or whether you are providing them an exit or you are really representing them, in all three scenarios, this becomes again another more like a most deliberated points nowadays, whether we call it a red flag or no, but it's certainly a key critical item. Does not warrant a very new sort of a structuring around it, but it requires understanding and a kosher navigation around this point. I think worthy of factoring it into the deal timeline as well. Samir, over to you.
Understood. So maybe why don't we continue, Karthike, with you, and really the theme from what you said earlier. And foreign investment laws, I think India is one of the few. Sharan made the point of capital account convertibility. India is still one of those countries that practices exchange control, and particularly on foreign investment. Several other countries have now introduced foreign investment caps somewhere around COVID and so on, as national interest is taking precedence. So in your experience, Karthike, how should transaction teams handle foreign investment laws and sectoral caps, whether it's India or otherwise?
So I think you are right, Samir. I think that also becomes a point which comes up almost every time when the deal is happening. And I think a basic theme is, I mean, the way I see it, I see that if you can't draw this structure on a piece of paper, you can't really close it. If you yourself are finding it too difficult to draw, I mean, that becomes really a point to deliberate on these structures. But for the team which is getting engaged on the diligence part, I'll simplify it. I think you start with a cap table, a structure chart, and if you are able to put everything on a piece of paper, then the things are much clearer. Okay. Again, I mean, if I were to perhaps put down a formula to it, I would use a formula called capped. Okay. I would look into the sectoral caps. I'll look into the attribution, whether it's a direct, indirect, flowing through FOCC, IOCC, front, back, what you are doing. So the attribution of the capital. Then perhaps I'll look into pricing, the CAP. E would be your really the exception to the rules, where you can find, and again, and the local sourcing and all those conditionalities around the sector. What are the exception? Can you really fall B2B and whatever you workarounds you have available? And the D is again the downstream and related bit. So the moment I think you follow CAP and you keep your eye on the same first three principle I narrated: permission, prudence, and path, to check for the target's business, seller or promoter, whosoever, and the investor. And the entire theme around those three people here and the business, along with the CAP principle, I think you will be able to navigate and figure out at least the foreign exchange compliance very clearly. Of course, the filing, reporting, all those comes into play and things happen. A couple of interesting things we started seeing, and again, not one example, two example on this front, but I'll simplify it in my way. There have been deals where you would find form FCGPR or FEMA filings have been missed out in the past. Okay, I think back in the day, there were a lot of deliberation. Now we all understand it's a procedural lapse. Regulator has been very kind. They provided LSF, I mean, late filing, and then all those opportunities. But those go back only for certain years back, right? I mean, you can't really look for something which has been a decade old or so on and so forth. Then compounding is a path. That is also perhaps okay. Regulator is very sensible and they understand what is a real miss, what is a non-deliberate miss and all. That the challenges start to come in when you will find situation when the banks which were the AD or who allowed you to remit the money back in the time, they don't really operate in India anymore. And then to do a basic KYC, because the whole principle of compounding is that now you clear it. So you need to file a form FCGPR now, you need to get a KYC done. At times, I mean, it's also unfortunate that those buyers are no more, I mean, they are alive and then the transmission has happened and new people, they are struggling with KYCs and all. These processes really become a roadblock. If it is for a strategic buyer, it's okay because then they have time to clear it out. If it is for a private equity or a focused investor, financial sponsor, then they are looking for an exit in next few years. And then if these things are not cleaned up, it becomes a big hoop and a roadblock for them. So that's another one. I mean, we faced one deal which got kind of delayed for a good 6 months. owing to one of these situations. A famous bank which was used to operate in the first decade of this century wrapped up its business, and there was no KYC. But yeah, I think this is how I would perceive. Samir, over to you.
Understood. And if I were to just bring in Sharath, and Sharath, sectoral caps, sectors, all of that Karthik spoke of. Now, depending on each different jurisdiction's priorities and each different jurisdiction's geopolitical circumstances, they have certain sensitive sectors. Particularly in the context of India, I would say defense, I would say telecom, media, there are certain parts of fintech. All of these tend to be very sensitive sectors. What do you do differently when you're diligencing a target in these sectors?
I think first and foremost, you need an expert, whether you are doing an inbound or outbound. We have been very lucky that we have, in-house specialists within the firm. But when you are looking at outbound, clearly sectors not just like telecom, aviation, defense, aerospace, satellite technology, artificial intelligence, pharma, healthcare. These are all significantly regulated and restricted sectors. So unless you have mm, a specialist in that jurisdiction who can tell you all sorts of nuances of that investment, I think that would be really my first activity if I'm looking at it sequentially. You have to pay attention to, say, licensing conditions. Are there local partner requirements? Are there residency or nationality requirement for any of the KMPs? Are there requirements like some of the African jurisdictions do require the black empowerment entities to continue to hold a minority stake? Some of the Middle East jurisdictions require government approvals for transfer of even a minority stake. So all of that you will have to really factor in delay in clearances is something which can become unpredictable. So in terms of inbound, it's not you encounter that only for outbound, but it is quite likely that in sectors like mining, the licenses and your permissions to operate businesses like mining, these are not transferable technically. These are new licenses need to be applied for. It's a full thorough scrutiny of the acquirer right from scratch, and all of that can derail the process in terms of closing of a transaction. In some jurisdiction, of course, merger control filings, although it sounds procedural, but it can raise some important issues before the competition authority. So those are, I mean, some of the examples. The management structure approvals, as I told you, that can lead to if you need pre-clearances for appointment of key managerial people, and without that you can't just step into the management control. Those are some of the examples which I have seen in real practice. Over to you.
Understood. Understood. And let's say if the target, I'm just wondering if the target is not in one jurisdiction, it's across jurisdictions. You also have to then pick your battles because at the end of the day, the deal has a certain timeline. Parties want to function to a certain timetable. So, Siddhant, in your experience, if there's a multinational target which is spread across different geographies, how do you build in some semblance of priority or take a semblance of battle first?
See, diligencing a multinational target, different jurisdictional presence, is always difficult. But for any large engagement, and for that matter, any other large work, you will have to do some prioritization in terms of where you want to focus versus not. Typically, the rules which we use, like an 80-20 rule, we'll identify what the priority areas are. And a very large role which goes in terms of identifying the priorities would be interacting with your client, identifying what the deal dynamics are, what the deal objectives are, why is it that we are really evaluating the target, and what's kind of going to do a value impact versus a deal impact. Understanding those and then identifying in terms of what are the jurisdictions which are slightly more risky, identifying the critical assets which are there within the company which you are evaluating and the multinational you are evaluating, and laying down the plan. In fact, I would say once we have created a plan, almost 60% of the diligence is kind of done as you have identified focus areas. And typical focus areas in majority of these multinational transactions would originate into 4 or 5 buckets. From a finance and legal and tax point of view, we'll identify in terms of what are the key value drivers which would impact the valuation almost on an immediate basis, and what are the commercially impacting matters which will impact the deal, whether the assets and the client's decision to kind of go or no go with the asset would get impacted apart from the value. And these would largely being folded into identifying, what are the financial and accounting hygienes and tax and legal compliances. So I would put that as one bucket, which is very, very basic and has to be done in potentially all the deals. So that becomes one priority. The second priority, at least from a finance and tax point of view, becomes understanding how the revenue and margins have played out. Identifying what have been the key drivers to revenue, what contributes to the growth of the business. Is it customers? Is it new jurisdictions? Is it new products? Are they entering into new margin profiles? And breaking it down, for the deal evaluators at the client side, and laying it down clearly in terms of what contributes to what aspects of growth, so that the growth can be deciphered. And then kind of moving into the other parts, moving into balance sheet items, identifying how risky the assets are. Are they collectible? Are they legit? Focusing there to identify to what extent there are risk areas identified, and working back with the legal counsel to understand to what extent they can be protected through documentation, through transaction documentation, and versus value adjustment. So having said that, another very important aspect is whether the deal is competitive or not. In a highly competitive deal, which are auction scenarios, we'll have to again reprioritize certain areas to understand in a multinational scenario where to focus first versus differently. And hence, some of the requirements would be tweaked, and the prioritization would again be tweaked to that extent. I think. Yeah, go ahead.
Go ahead, Siddharth. Sorry, go ahead.
No. So these are the matters from from where you would prioritize. From a tax perspective, identifying how the deal structure would flow, which are the investor entities and the investee entities, and identifying the correct structure so as to kind of minimize tax and cash leakages. I think that would be one of the priority questions or the priority areas which we would focus on. Back to you, Sameer.
Understood. Thank you very much. And I'm just conscious of time, and the chat box has been buzzing with questions. So maybe what I will do is I will flip now. We'll end the panel discussion here. We did have a couple of other subjects to discuss, but it's been such an engaging discussion. We've obviously overshot time, but nonetheless, let's come to Q&A, and I'll try and pepper each one of you with some of these questions. I'd request you to try and address as many of those as you can. So maybe why don't we start with let's say some good practices. And Siddharth, one question to you would be: there's an interesting question on any suggestions on good practices on virtual data rooms that you've seen in your experience. I think that's something which we'd love to hear from you.
I think most of the data rooms which are available in today's modern day practices are all valid. They have almost similar functionality, be it a data site versus any other data room which you use. They provide you adequate restrictions as a seller and adequate access as a buyer to kind of go through documentation, raise Q&A, and provide some structure to the madness, especially in a multinational and a multifaceted deal. Having said that, Sameer, what could be challenging in a cross-border diligences in terms of how data would be shared? some of the jurisdictions, they would have restrictions in terms of sharing information due to data protection laws. At several places, we find challenges with respect to sharing of employee-related data, where either we'll get only summarized information, or kind of jumbled information or scrambled information, so that while we can still make commercial and economic sense out of it, but we'll probably not be shared information. So in such cases, we have to kind of resort to alternative means in terms of setting up an SFTP server to securely transfer what is kind of required, not breaching local data sensitivity matters, while kind of still proceeding with the deals. We have also seen, with respect to commercial matters, commercially sensitive matters, there could be instances where, like in my earlier example or the story I kind of quoted, with two similar businesses coming together, there could be commercial sensitivities where for the advisors, you may have to kind of set up separate clean rooms. But again, there are several issues and several matters which can be settled through those.
I'm glad you picked those points up, Siddhant, because there were questions on clean teams, there were questions on data privacy. So I'm glad you sort of rolled all of that up. But Sharad, there's an interesting one which I'd love to hear your perspective on. Let's say if there's a target which is not willing to share information due to secrecy laws. I wonder, maybe in public procurement or other similar sectors, how do we deal with that? Let's say if you're diligencing a target of that nature.
So I think for making a decision of whether to proceed, do we have enough data? So I think identification. So I have not seen particularly secrecy law, but let's talk about pure confidentiality. That nobody wants to really share the names of, say, top five customers or top five suppliers, or any details of employees. What Siddharth talked about. I guess at least to begin with, anonymized or aggregated data has definitely worked, because you are looking at the financial modeling of, or the credibility of the potential transaction. You are not, at least at some in the initial phases of diligence, until you come up with a definitive document. You may not be looking at identities of specific customers, suppliers, employees, and so on. But beyond a point, I think these will have to be disclosed once you get into a definitive documentation. At the initial information sharing, uh, I think redaction has worked very well. I think that's a great practice. It has been done in several jurisdictions. So I don't think it's not a stopping your exercise, but you may have questions which you may want to wait until a more definitive stage in the entire negotiation has come up.
Understood. So maybe now there's flavor of the season is of course tech and AI, artificial intelligence, generative AI, and its applications. And there's different questions on that. But if I have to try and sort of bundle all of them up, and I'd love to hear, Karthikeya, your thoughts, and maybe even followed up with Sharad and Siddhant, because this is something which impacts everybody. How are we currently using generative AI to make diligence more meaningful and wholesome? And what are the additional applications that you see in your experience or in your sort of thinking, where either tech or artificial intelligence can really be useful? So Karthikeya, and then after that, Sharad, Siddhant.
So, Samir, I think, I mean, tech and AI, and I'll keep tech out. I mean, I'm simply using AI, which encompasses tech as well, is anyway part of our, daily routine, I guess. And anyone who is running it today or doing a fairly decent size operations practice, they would be using it. Otherwise, they're not relevant. So I'll start from a very ab initio stage. The very first time you get to hear about, and very interestingly, the Secrecy Act, or let's say a sector which is like defense is booming up, a lot of transaction there. You are to do a diligence on a particular sector, you have not interacted, it's opened up recently. I mean, the first step will be to understand the peers, industry, the risks, what are there. Everything can come up through AI, general, no name search. So that's first one. And it's not only about the leaders on the deal or the advisors on the deal. I mean, the advisor team also comprises of all level of, people who will support the deal. but people to have a macro level of understanding about the target or the deal helps you navigate very well. So I think if this AI tool or AI in general is available to your organization or your advisor's organization, the entire team which is working on the transaction will become much more advanced and well understood in terms of the macro picture of the deal versus, the back in the day, when one person knows the entire story and rest are only knowing the hands and legs. So that's simple, part one. And then we'll come to, the advent of Kira and thereafter to Legora, to Harvey's, to several other, including in-house Ask AI and others, where you can put in the document what you can get out, what you can't, how much you can rely. All those are very, differ from organization, nature of document you are pumping in there, what you want to get out of it. But I'm saying, generally, the role of AI would not only be to empower, enlighten, but also, the way the diligence reports are being prepared and given to the client. One can prepare 500-pager diligence report while issues lies between 20-pager, and they are just spending nights reading it. You can curate it. I think back in the day we curated, and I think that would have been one of the question, if not already, that how you really transpose the DD finding into a document. Ultimately everything has an impact. You curate it so simply for the client so that they understand, especially the one who do it, like day in, day out on these front. If this be the issue, this would probably be the ask from the buyer, whether it's adjustment to specific indemnity, warranty, or tomorrow, even if you go for a warranty indemnity insurance. So your data room, everything. So I'm saying the AI is not helping you understand the issue. It also helping you how to present. And in between the process of the lawyering time being reduced through AI, that's a subjective discussion. I think one may argue it's conclusive, it's non-conclusive. One may argue, no, it is really good. But that's just the journey. It has started. Perhaps a year down the line or so, we'll be in a better position to really give a conclusive thought on that bit. But I'm saying the beginning and the end is certainly impacted by this tech, and the process itself will get impacted. It is being impacted today, but in a better way down the line. That's my take.
Thank you, Karthikeyan. Quick word, Sharad, and then quick word, Siddharth.
So AI tools, like Karthik said, I think we have to work with all the AI tools, whatever is available. I think one word of caution, that we can't entirely rely on the output that is delivered to you. There will have to be checks and balances. There will have to be revalidation. Although you may give instruction, no hallucination. Whether the data mining has given you accurate outcomes, accurate details. Say, for example, there are litigations, or there are notices issued by regulatory authorities. Uh, Once these kind of at least directional outcomes are shown to you, then you know where to deep dive and do a deeper research. But I think AI is a fantastic tool to give you a crystallized, in a very summarized form, but it will need a lot of human intervention to interpret what you have and then apply it for a transaction. You can't just rely on the output as is.
Perfect. Siddharth, over to you, and that will be the final word on this.
Sure. No, it's a very interesting topic, Samir. We have come a long way and, kind of progressing very fast on AI. And, the way, at least at EY, we have been using, of course, both internal and external tools. One, it is becoming a lot more faster for us to go back to the client, navigate through the deal faster, because we go to the issues a bit faster compared to earlier. And of course, our clients expect to use the available technology to do that. So it's helping us kind of easing out the timelines with the client, because especially in an auction scenario where you have, say, 5 bidders, and you need to kind of be the first one to kind of show steady pace on the deal. I think AI is definitely helping and supporting us to do that, and navigating through issues and the deals faster. In fact, the entire advisory team's time is becoming far more relevant, because some of the process related jobs is something which the AI and our internal tools are taking care of, and we are going back to our clients with some more relevant insights and what matters on the deal, rather than kind of as Karthikeya mentioned and Sharad mentioned Wikipedia related stuff. It's no longer FYI, and hence it's more insightful. And specifically in a multinational, multi-country scenario, it helps decode through languages. It's becoming far more easier to kind of sit in India, sit over here, and kind of do outbound deals because the documents gets translated. Several of the larger players and larger advisors have their own internal tools and internal servers, which means you're no longer kind of taking these documents to public domain for conversions, and hence both from a data secrecy and speed perspective, it's becoming far more meaner and sleeker. I think it's a lot more to do on AI, but I think we are seeing a good momentum in terms of how it's kind of adding to the worth of advisors, specifically in an M&A and a transaction scenario.
I think fantastic, and thank you very much to all of you for concluding that part. We're quite a bit of in terms of time overshooting. With that, thank you everybody, whoever participated in the poll. And without a doubt, I would like to thank all of our panelists today for sharing their expertise and their experience. I would say each one of you was outstanding, and I'm sorry we fell short of time, but ladies and gentlemen, their contact details are available to you. If you'd like to set up a separate conversation, they'd love to talk you through any other questions you may have. And this is such a vast field that is really impossible to summarize anything and everything that can be of relevance. But once again, many thanks to our audience for your attention, your questions. Incredibly participative webinar this one was. And we really do hope that you found this webinar interesting and engaging. And it really is a pleasure and a privilege to bring such webinars to you. Please do separately respond to a request for feedback that you will receive. We've tried our best to keep the form very short, and we welcome all sorts of feedback, whether positive, negative, criticisms, compliments, everything is most welcome. If there is any interest at your end in in-house training or any other matters that may arise from the webinar, please do reach out to one of us. Our contact information is in front of you. Thank you very much once again for your attendance today, and we look forward to being of service at future M&A Masters series.